Hello, everyone, and welcome to today's webinar presentation, Predictably Unpredictable, Navigating Fair Workweek Laws Across the United States. Coast to coast, cities and states are implementing predictable scheduling or fair workweek laws. These laws often have aggressive administrative agencies enforcing them, with 7- and 8-figure settlements already recorded. During today's webinar presentation, Littler experts will provide you with an overview of each jurisdiction's rules and helpful strategies for achieving compliance with them. Before getting further into today's topic, I would like to take a moment to introduce myself and my organization. My name is Stephanie Zielinski, and I'm the Marketing Director for complianceHR. You may recognize my name from the invitation emails you received for today's event, and some of you may have even emailed me directly about this presentation. So to prevent a few popular questions from entering the Q&A box, I'd like to let all of you know that this presentation will be recorded and it will be emailed to each of you. Please keep an eye on your inbox for an email from complianceHR webinars. Now, a bit about complianceHR for anyone who may be unfamiliar. complianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler. complianceHR delivers expert employment law guidance in a fraction of the time that you would otherwise spend with traditional methods. Our goal is to simplify the complexity of employment law, something we will learn a lot about during today's presentation. Now, to achieve that goal, complianceHR offers a suite of solutions around critical HR compliance topics like employee handbooks, employee overtime, independent contractor classification, onboarding, leave, and we even have a rapid reference tool that supports many other topics. Today, however, I would like to focus on our two most popular solutions, PolicySmart and the Reference Center. PolicySmart is a comprehensive employee handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and it even sends automated emails to alert you on new legal changes going into effect across the U.S. The Reference Center is a solution that combines key employment law and HR compliance topics, such as final pay, workplace posters, FMLA, minimum wage, predictive scheduling, and many others. Created to help HR, legal, and compliance professionals do their jobs more efficiently and effectively, this solution leverages data directly sourced from Littler to ensure compliant answers to your critical questions. Now, if you're interested in learning more about these tools, a survey will pop up on your screen. You may have to exit full screen mode to view it if you're currently in full screen mode. If you'd like to receive a demonstration of the Navigator suite that is tailored to your organization's concerns and risks, simply answer yes, and I will send your contact information to our team of experts. In addition to a demo of our solutions, you may be eligible to receive a free trial of our products so that you can see precisely how much time and money they will save you. While I let the poll run for just one more moment, I'll answer the question you may be wondering. How do our solutions fit in with today's topic specifically? PolicySmart supports HR and employment law professionals with jurisdictionally compliant policies for the areas in which your organization operates. Further, our unique policy effective date timeline clearly shows not only when policies go into effect, which gives you and your team time to implement them, but also which policies require a mandatory update to your employee handbook. However, the Reference Center may be the tool most helpful for today's topic. The Reference Center offers information on predictive scheduling specifically, and there's a report which breaks this topic down into subtopics like covered employees and employers, scheduling requirements, employer obligations, and additional information. The Predictive Scheduling Report allows you to compare jurisdictions side by side to ensure compliance with even the most stringent local requirements. So again, if these solutions sound like they would help streamline your organization's compliance strategy, please select yes on the survey on screen or visit compliancehr.com/demo. If you're not sure at this time, I'll launch the poll once more before we conclude today's presentation. Now, I have the pleasure of announcing today's presenters. With experience creating workplace solutions to navigate local, state, and federal regulations governing the workplace for small businesses and enterprise-level corporations alike, Martha Keon Ailey Friedberg and Andy Clavin-Feingold are experts on today's topic. Ailey, I will pass it over to you.
Thank you so much, Stephanie. I really appreciate that introduction about complianceHR's tools, and I know from a lot of clients who use them, they're really fantastic. So thanks for that, and thanks for hosting today's webinar. It's the topic, obviously, as all of you listening know, is Fair Workweek laws. It's a topic that is very close to my heart, Martha, and Andy's heart. We the three of us and some of our other colleagues, we're a part of Littler's core group that addresses these issues on a nationwide basis. Martha is based out of Philadelphia. I'm based out of New York. Andy's based out of Columbus, Ohio, which fortunately doesn't have a Fair Workweek law. But Andy has become really a nationwide expert and really a go-to resource for questions about Chicago and many of the West Coast jurisdictions that do have the Fair Workweek laws as well. I got into the Fair Workweek world back in 2017, late 2017, when New York City first passed the law, and realized really at the outset, when the bill was still being debated in the New York City Council, what a mess this was going to be for New York City retailers and fast food employers who are covered by the law. It was apparent from the face that the law itself was really a game changer and intended to be a total disruptor in how fast food companies and retailers do business in New York. And I'm not always right, but in this situation, I certainly think I was. The laws are ambiguous, they're complicated, probably purposefully designed to be that way. At least based on the folks who were in charge of lobbying for and writing the laws. And really, since 2017, Fair Workweek has become a very, very major part of my own practice. And I know the same could be said for Martha and for Andy. I remember when the Philadelphia laws were being passed through the Philadelphia City Council, Martha and I actually met with some representatives from the Philadelphia mayor's office and city council, and actually put on some in-person presentations at that time to discuss the laws. And while each city's, and in the sense of Oregon, the state laws are all different and nuanced in very, very fundamental ways, there are some similarities, and similarities being that they are disruptive. And the point of today's webinar for us is to go through the laws and specifics. We're here for about another hour and 20 minutes or so, and really we could spend probably 2 full days discussing the ins and outs and the ambiguities of each laws. So we're going to be providing a pretty high level overview today about the major components of the law itself. And in terms of the agenda, some of the topics we'll be covering will be just an overview of which types of employers and employees are covered by the law. I noted earlier that in New York City, the law covers fast food employers and retailers. That's not the case everywhere. You go to a city like Chicago and the coverage is much broader, and we'll certainly get into that. You go to San Francisco and it covers formula retailers, whatever the heck that means. We'll discuss some of that later in the presentation. We'll discuss the requirement that is present in most, but not all jurisdictions to provide good faith estimates, which is typically just a document that says these are the times you can expect to work through the duration of your employment. We'll discuss requirements that require covered employers to provide advance notice of schedules. Usually, again, not always, most jurisdictions require covered employers to provide schedules with at least 14 days advance notice. That does change here and there within jurisdictions again. We will cover schedule change requirements. What happens when an employer changes an employee's schedule after the deadline to produce a schedule in the first place? There are a myriad and host of requirements when these schedule changes occur, including requirements to repost schedules, individually distribute schedules, obtain consent if you're adding hours, and very often, and probably most fundamentally, requirements to pay premium pay for most types of schedule changes. We'll discuss what we call clopenings, which is prohibitions really in scheduling employees over 2 days with less than a certain amount of time between the end of the first day's shift and the beginning of the second day's shift, and what you have to do if you're going to schedule an employee for one of these types of shifts. We'll discuss prohibitions on hiring new employees before you make offers to your existing employees. This we call access to hours requirements, and I will just editorialize here a bit. Access to hours is probably the least complied with of all requirements in fair work week jurisdictions. It is extraordinarily hard to even decipher the statutory requirements of when access to hours is required and how you go about doing it. Many of you who are covered may have electronic vendors who try to automate your Fair Workweek compliance process. I am not personally aware of any vendor that has been able to automate the access to hours requirements in these laws, although I'm sure many of these types of vendors are working on that. We'll talk about how, specifically in New York City, the Fair Workweek law has been amended and expanded to essentially eliminate at-will employment in fast food, in the fast food industry, where you're not able to change, really terminate employees for any non-discriminatory reason, but it's only permitted in certain circumstances where you've gone through progressive discipline processes if they were a unionized employer. We'll talk about the various jurisdictions' requirements to post notices about employees or about employees' rights under the Fair Workweek laws, and we'll talk about how we are seeing in our practices cities, states, and plaintiffs' counsel enforcing these various laws. Again, we will, because we only have an hour and a half, and I know that's a big dedication in all of your work days to come tune in, and we're very, very grateful. Because of all the nuances and the proliferation of these laws, we can only talk about these on a high level. But I did want to note that there are certain jurisdictions that have Fair Workweek adjacent laws. They don't necessarily have the type of requirement, like they don't have the type of requirements to pay premium pay necessarily. There are jurisdictions like San Jose that only have access to hours requirements, or other jurisdictions that require employers to consider employee availability before posting schedules. Those laws are going to be a little bit outside the scope of what we're talking about today, but certainly if you have any questions about those, you can reach out to Martha, Andy, or I, and we're happy to walk you through those jurisdictions' Fair Workweek adjacent type laws. And again, what we will be covering are the jurisdictions which have the red dot. We'll be talking about Chicago, we'll be talking about Philadelphia, New York City, Los Angeles, San Francisco, Emeryville, and Berkeley, Oregon, and Seattle's Fair Workweek laws. And with that, I am going to kick it off to Martha. Talk about who's covered.
All right, let's talk about coverage. So we could spend a long time on coverage, and because of that, we created some charts, And I'm going to be toggling through this slide and the next slide back and forth while we talk about this to show you what you need to look at to determine if your business is even covered. First of all, obviously you need to look at the jurisdiction, look at the confines of the jurisdiction. LA County is a newer ordinance that just went into effect. And so you need to figure out if you have operations in the unincorporated parts of LA County that are outside of Los Angeles. Los Angeles had passed an ordinance back in 2023, but LA County now has followed suit. So you need to look at your business, look at your jurisdictions, and then you need to determine if your industry and your location type for your company is covered within that jurisdiction. And as you can see from this chart, there is no one size fits all. This predictive scheduling started in San Francisco and it branched out. That was 2015. Then in 2017, Seattle, Emeryville, New York City, and Oregon came along. And generally, initially, these ordinances and laws applied to retailers and restaurants and sometimes just fast food. But then it expanded. Philadelphia expanded, as you'll see in the next slide, to include hospitality. And Oregon did as well. Chicago and Evanston followed suit. We have Euless, Texas, which came on in 2023, also covering hospitality. And then you'll see Chicago and Berkeley ventured out beyond hospitality to many other industries. And that was a big expansion of these obligations. So in looking at whether or not you are a covered industry, there are different things that you need to look at depending on what the specific law says. I'll throw out an example. In Philadelphia, you need to look at the industry code. The ordinance refers to the NAISC code. And if your business has that code, operates under that industry code, then you're going to be covered. In other jurisdictions, like Ellie mentioned, San Francisco, they look at formula retail. Well, formula retail is something that's defined in an entirely different ordinance relating to, planning in San Francisco, and it has a very particular definition. It's not just limited to retailers of goods, it covers services too, but it's formula. It means like it has to have, like the business has to have a common trade dress, like a chain. So in each of these instances, you need to be very careful to determine whether or not you're in the industry and then whether or not the location type is covered as well. So for example, it may not be obvious that in Los Angeles, retail may include a retail warehouse, not just the point of sale retail business. In Philadelphia, by contrast, they really are looking at point of sale type retailers where you're interacting with the public. So this is a long way of saying that for each of these jurisdictions, to even determine if you are a covered industry and or location, you need to look at the specific language of the ordinance or law, the regulations, and the FAQs. Many of these ordinances were drafted at the local level by lawyers and non-lawyers who are not familiar with employment law and employment law concepts. And so some of the definitions are incomplete, confusing, internally contradictory. And so there may be something stated in the law that then is clarified in a regulation that then is even further clarified or sometimes contradicted by an FAQ. So all of these jurisdictions have websites that provide links to all of the sources of law and also guidance. And so that in addition to these great complianceHR resources, going down to determine specifics, often you really do need to go down to the granular level and look at the actual law, regs, FAQs, and consult with someone who is familiar with how the city is interpreting things and the extent to which they're going after certain issues. So in addition to looking at covered industry, you can see here that we have a column on the right for the size of the company. So these laws generally look at not only the overall size of the employer in terms of how many employees you have anywhere, but also how many employees you have in the locale. Typically, they're looking for large operators, but they define them all differently, as you can see here. Many of these laws are going after chains, but also franchises. So if you're in a franchise organization, even if you are an individual franchisor that just might have one location, you could still be covered under this law because you're in a franchise organization that is going to be considered covered. And so this is very onerous. It can create a real competitive disadvantage because it's clear that a bunch of these ordinances, like for example, in Philadelphia, which I'm most familiar with, operating, competing with local businesses who are smaller, who are not chains, who are not subject to this ordinance. There are different rules that apply to you if you're covered by this ordinance, so it can be really tough. All right, so determining the counting of the employees is something that can be very complex because you have to determine whether or not you're supposed to be counting all employees or just the employees who are covered under the ordinance. So this needs to be looked at carefully. And the reason is that if you're truly not covered, you're not going to want to be complying with all of these obligations because they're onerous. If you are covered and you miss that, that can be a real problem because the penalties and fines and in some jurisdictions, class action exposure is really significant if you're not following these laws and you get a complaint and it turns out that you are covered. So coverage is something you need to look at very carefully and in conjunction with, as necessary, with counsel to sort of help you determine it. Okay, so if you're a covered employer, you need to figure out who are your covered employees. So who within your organization in these jurisdictions do you need to follow all these rules for? So generally, these ordinances apply to non-exempt employees. This requires a clear understanding as to who is non-exempt and it increases the risk of misclassification of employees. And some of the jurisdictions also have salary, pay thresholds, above which you wouldn't be covered, but below which you would be covered, like Berkeley and Chicago. And in the case of, and they increase from year to year. So it's something you need to keep an eye on because it may be that at some point the person wasn't covered, then later they became covered. So these definitions need to be kept in mind and looked at carefully. All right. Next, we're going to turn to the good faith estimate. So the good faith estimate of work schedule is basically intended to tell employees at the time of hire when they can expect to work so that they can plan the rest of their life, either another job, their family obligations, or education, or whatever they're doing. So the intention is to let people know when they can expect to be scheduled. So generally, under all these laws, it's really considered an estimate and it's not a contractual offer. Although we'll talk about New York City fast food, it kind of verges on, feels like it's getting close to a contractual offer. But what the good faith estimate is and how it's used differs by jurisdiction. So San Francisco, as I said, was the first one of these ordinances that was passed. And the good faith estimate there is just a minimum number of shifts per month and estimated days and hours. So that document looks very different than some of the other jurisdictions. Oregon, a median number, so the middle number, not the average, but the median number of hours per month you can expect to work. And then when Seattle, they want the median number of hours per week in 3-month increments for 1 year, and if you're going to work on call hours. So it's getting a little more specific. People want to see what their work week looks like. In Berkeley and Emeryville, it's your estimated weekly schedule. And then when you get into other jurisdiction, it gets more and more specific as to what needs to be put within the good faith estimate, average hours per week, if you're going to have to work on call hours, where the location of where the shifts will be, and the range of days and times you can expect to work. I'll just say that for on-call hours, for Philadelphia and some other jurisdictions, the utility of even having on-call hours has been completely eviscerated, because if you schedule someone to be on call and you don't call them in, then you have to pay predictability pay. So you might as well just have scheduled them. On call in some jurisdictions really no longer is helpful to have as part of your scheduling. And then in New York City for fast food, the good faith estimate is really more like your regular schedule. So, and it has a 15% capped on reduction without consent. So the idea of the good faith estimate has definitely evolved over time, from when these ordinances initially started being rolled out until now. So when does the good faith estimate have to be provided? Even this is not the same. You would think this would be an easy question. In Los Angeles and LA County, which are two much more recent ordinances, you're expected to give them before hire, like with the offer letter. So the idea here is that in the bargaining as to, in hiring this person, you're supposed to be telling them during the offer and acceptance process when they're going to be working. Oregon and Seattle, it's at the time of hire. San Francisco, Chicago, and Evanston before the start of employment, which that's a little vague. Berkeley, Emeryville, New York City fast food, no later than the first day. In Philadelphia, they give you a little bit more leeway. They say no later than the first day or the last day of new hire training. But that new hire training has to be documented new hire training. It can't just be loosey-goosey, yeah, we showed people how to do it. So if you get an investigation, you're going to have to show, yeah, here was their first day, here was their training time. Ideally, you'll have like training codes in your payroll to even prove that it was training. And then, that would be the last time you could give their good faith estimate. So the compliance strategy here for good faith estimates is to, really be cognizant of when the deadline is in the jurisdictions and incorporate them into your hiring and your onboarding process. Okay, so in some jurisdictions, there's kind of like an interactive process requirement regarding scheduling if an employee asks for a schedule modification. So this really could occur at any time. Most likely time it occurs is kind of right at the beginning. So if the employees ask, if you're, say you issue them a good faith estimate and it has a day in it that they really don't want to be scheduled, they may say, hey, I really don't want to have to work on Tuesdays, can we change my schedule? In some jurisdictions, you're required to respond in writing and within a specified number of days. And then denials of employee schedule requests sometimes need business justification in some jurisdictions. And so you really need to check the specific rules on that. And so one way to sort of avoid getting into that conversation is to have a structured process in place where you're determining the employee's availability from them before you're issuing the good faith estimate. So that tends to avoid the issue to begin with. So once you issue the good faith estimate, don't throw it in the drawer and ignore it. The purpose of the good faith estimate is that you're supposed to then use it in scheduling that employee. So generally, you should be following it. So the question arises, okay, well, if needs change, do I need to update it? So it varies by jurisdiction. So there's no duty to update it in Evanston. It's not really addressed specifically in Berkeley, Emeryville, San Francisco, or Chicago. In Seattle, upon request, you may have to reissue it. And then in the other jurisdictions, it's really more, it's more regulated. In Los Angeles and now LA County, you need an unanticipated, documented, legitimate business reason for substantial deviations from the good faith estimate. In Philadelphia, if your business needs change and there's a significant change to your needs, they're going to have you issue and you have to issue a new GFE if in 6 of 12 weeks you have variances that they define in the ordinance or in the regulations. So if the hours vary by 20% or more from the average, or if you schedule someone on a day that's outside of the days that they were going to be scheduled in the good faith estimate, or if it's an hour more outside of the range of start and end times in your good faith estimate. So in Philadelphia's kind of got a very specific way it lays out its good faith estimate. You're supposed to not put the person's expected schedule, but a broader range of hours within which they might be scheduled that can go up to 1.5 times the average hours that you list in the good faith estimate. So if on average, someone's going to work 20 hours a week, you have 30 hours to play with in filling out your good faith estimate. And you want to use all of those hours because you don't want to trigger a good faith estimate if you don't need to. And if you don't use the whole range, then you're more likely to have a significant change. New York City for fast food is extremely restrictive. You have to update the regular schedule, which is like the GFE, before issuing a schedule with that change. So that's really the overview of good faith estimates. I am going to turn it over to Andy to talk about advance notice of schedules.
But before we get there, Martha, and start to interrupt Andy, there are a couple of questions in the chats that I think might be a good time to address now. And by the way, for everyone listening, use the chat box. We are monitoring it. We'll try to get to as many questions as we can. Can't promise that we will during the presentation. We will certainly follow up with you after the webinar to answer all substantive questions that we get. We've got two very similar questions, and I'll pose it to you, Martha.
Yep.
One of the attendees is asking, is a good faith estimate a written document provided to the new hire? And another attendee asks a similar question. So do these good faith estimates need to be in writing during onboarding?
Yes.
What do you think about that?
Yeah, great questions. They do. They need to be in writing. And ideally, you want to be able to show when you gave them to the employee. So they need to be written. We have formats that we can share. Each jurisdiction, not all of them, but some of them post templates on their website. But I'll caution you that some of the templates are not very self-explanatory, and it kind of leads to them being filled out wrong. But it definitely has to be written. You want proof of when it was issued. So if you issue it electronically, you'll want to be able to show an electronic timestamp so you can show that you issued it timely and that the employee actually got it. Many people just have a written on a piece of paper, and they go over it with the employee. They have the employee sign it, and then they give the employee a copy, and they keep the original, and they keep all their Fair Workweek stuff together, and then they scan it into they might scan it into a good faith estimate folder. We're going to talk about record keeping requirements at the end of the presentation, but you definitely want to be mindful about collecting, not only just getting these things done, but being able to find them when the time comes, because in order to defend against a claim or an investigation, you're going to need to supply the proof that you did these things.
Okay. Yeah, I agree with that completely. Yeah, I'm sorry. Just one point before we kick it off to Andy. And Martha's right. We will get to the record keeping at the end. Generally, these laws require, for the most part, retention for between 2 and 3 years. I always recommend clients to keep all documents required by these statutes, which typically include the good faith estimates, the schedules, time records, pay records for a minimum 3 years. If you have hard copies of these records, make sure you have a mechanism to scan these documents, save them to the cloud, so we know, just as Martha said, if and when the time comes when a city agency or God forbid, a plaintiff's lawyer is seeking discovery about these things, we have them accessible. With that, kick it off to Andy.
All
All
right,
right, and
thank you.
just before Andy jumps in, there are a few more questions on coverage that are very specific. So I think they'd best be handled after the session. We'll be able to respond to you offline.
All right, so advance notice of schedule is the kind of primary purpose of these rules initially until they snowballed into what they've become. Um, The general rule across most of these jurisdictions is that you have to provide the schedule 14 days in advance of the first day on the schedule. Meaning if a schedule begins November 15th to the 20th is that work week, you need to provide the schedule to your employees 14 days before November 15th. Now, what that one, there are always exceptions. One exception initially is that if you have a new hire, or if you have someone returning from an approved leave, like an FMLA leave or medical leave, upon their consent, you can add them to this schedule upon returning. So, with less than 14 days notice, if the employee consents to those scheduled days, you can put them on the pending schedule, and then moving forward, they'll get their future schedules 14 days in advance. Again, with their consent, no predictability pay would be owed, and that's a general rule across most of these jurisdictions. There are some, Euless, Texas, which I know went up on appeal, so Ailey can discuss, I think, if it's in effect or not at the moment. But another is 72 hours for New York City retail. Now, one thing that a good practice that we've seen some clients do that really work out for them is, to the extent possible, posting the schedule more than 14 days in advance. If you have the capability of doing so, whether it's 15, 16, or 21 days in advance, that buys you some grace, because as often, especially in retail and fast food establishments, and probably across the board, a schedule gets posted, employees look at it, and there's going to be initial changes, people realizing they have conflicts they didn't tell you about, and you can make changes in these jurisdictions up until the 14-day period without penalty. And so this buys you a little wiggle room, a little grace to make changes to the schedule and then post a final one 14 days in advance. And this may cut down on the number of changes you have after the 14-day period. One other thing, and it's particularly relevant in New York, whereas Martha mentioned this good faith estimate has become almost like a contract, is when your schedulers, whether it's a manager or someone else, is creating these schedules, a good practice is to look at the good faith estimates that are issued to these employees to ensure that, to the extent possible, your schedule matches up with the good faith estimate. Some of the stricter jurisdictions, it's more required, but across the board, this could be a good practice. All right, so the mechanics of posting. Typically, you can transmit electronically via the usual means of communication. And what this means is, if you use email, if you use a scheduling app, you're permitted to send the schedule out that way. Most jurisdictions also require that you physically post a copy of the schedule. So if you imagine a retail or fast food restaurant, there'll be a place where notices are regularly posted. Maybe it's a break room or near the manager's office. You would also be required to physically post a copy of that schedule. Now, as we've mentioned previously about record keeping, and are going to repeat often throughout this, that is one of the most important things here, is proving compliance with these regulations. I mean, these become speed traps when an investigator gets their teeth into you. They start asking for all of these records, for the scheduling, in addition to having a compliance schedule that lists everyone, even if not scheduled, all the employees who could be on this shift, you're in showing when they're working, you're going to need a date and time stamped schedule showing when it was posted to employees. Because again, if it's less than 14 days in advance, there will be penalties. And so, for example, in Chicago, where there is a penalty that you would pay to the city if they caught you doing this, where it's between $300 and $500 per employee per violation. So even if you posted the schedule 1 day late, 13 days in advance, and there are 20 employees on that schedule, 2 years later, an investigator shows up and catches that, it could be between $300 and $500 per employee for that 1 day violation alone. So, this record keeping, posting is important, but also having records that prove your compliance is very important. As we'll discuss throughout when we get into how these investigations are conducted, there tends to be a presumption against the employer, a presumption of non-compliance unless you have records that prove compliance. So this record keeping requirement, we cannot state the importance of that enough. It really is what you need to do to defend yourself against an investigation. Schedule changes. There are multiple types of schedule changes. Some result in premium pay or predictability pay. We use those terms kind of interchangeably. Some do not result in that type of predictability or premium pay. So typically, and again, always exceptions, but typically, if in less than 14 days notice, once the schedule is posted, less than 14 days before the shift, if the employer changes the employee's schedule, whether it's removing a shift, adding a shift, or changing the date or time of the shift with a loss of hours or even no loss of hours, that will result in typically 1 hour of predictability pay to the employee. Now, if the shift is changed with less than 24 hours prior to the beginning of that shift, so if on Wednesday night the manager removes a Thursday shift, in most jurisdictions there will be a payment of 50% of the loss of hours, and some cap that at 4 hours. So if you lost if an 8-hour shift was canceled, you could be owed 4 hours of predictability pay for that shift. If the employee requests the change, meaning a vacation, they're sick, or it's a swap between two employees, then no predictability pay will be owed. Now, again, harping on record keeping, there is a presumption during an investigation that when the hours worked do not match up to the schedule, that they're going to be considered employer-initiated changes resulting in predictability pay unless you have documents to prove that it was an employee-initiated request. So this paperwork record-keeping requirement, again, very important. Now, another type, a very common change that we see is when employees simply clock in or out early. Now, as we're going to discuss on the next slide, there are grace periods, but in some of these jurisdictions. But if the employee, say it's New York or Chicago, LA, San Francisco, cities with a lot of traffic or train problems, it's not unreasonable or uncommon for an employee to be more than 15 or 20 minutes early or late. Again, if we would consider that an employee-initiated change. They would just happen to be late or early. But again, from a record-keeping perspective, you're going to want to document that so you can prove it later on. Again, if an employee simply doesn't comply with the schedule, no call, no show, that would be employee-initiated, but the importance here is to document that. Now, as we mentioned, there are some grace periods that vary based on the jurisdiction. And what's interesting here is, Chicago, in the FAQs, it says specifically an employee simply clocking in early or late is not an employer-initiated change. Again, though, going back to an investigation, when investigators see a deviation of more than 15 minutes on either end, they're assessing a penalty if premium pay hasn't been paid, because they're assuming that it's employer initiated. So, again, the documentation, the coaching, training employees, how to, follow your procedures to clock in on time, to clock out on time is very important. Now, one note about these grace periods is some of these jurisdictions will say, 20 minutes on the beginning of the shift and 20 minutes at the end of the shift is okay. And some will aggregate the time, meaning a total variation of more than 15 minutes is a violation. So again, it's important to know where you are and how this grace period is applied. But again, you're going to want to train your staff and train your employees about the importance of clocking in on time to the extent possible, and when they're not on time, when they're clocking in or out early or late, more than a couple minutes, to document the reason, so that for posterity, so that later on you can defend yourself if necessary. I'm going to turn it over to Ailey.
Thanks, Andy. So we're getting into the part of the presentation now where things start getting fuzzy. And the reason things get fuzzy is because operationally, it's very difficult to know minute by minute, second by second, even often hour by hour, what causes deviations between an employee's schedule and actual work time. And it's very difficult to ascertain, assess, and most importantly, as Andy was just noting, keep records about what is the cause of a deviation between an employee's work schedule and their actual work time. Just some real life examples that I deal with on basically a daily basis when clients come calling is what happens when an employee clocks in 47 minutes late because their train was delayed? What happens when an employee clocks out of their shift 2 hours and 17 minutes before their scheduled close of their shift because they get a call that their dog is sick and needs to be rushed to the vet? What happens when an employee shows up early to work regularly or sporadically or every once in a while because their train was early, or they just happened to be really diligent, or they just happened to be in the neighborhood and they just wanted to clock in? What happens in that situation if the employee wasn't working, they were just chatting by the coffee machine or the water cooler and doing no work? Or alternatively, what happens if they start doing work immediately? They didn't ask permission from their manager. They just clocked in, 46 minutes before the schedule says they were supposed to. Alternatively, what happens if two employees catch the flu and your manager needs coverage for that shift 3 days in advance? These are all situations that happen for probably all of you on the call on a daily basis that you may or may not be managing or documenting. But if possible, well, I should say, if the Fair Work Week law almost mandates you to document the reasons behind all of these shift changes, because otherwise, as Andy noted and Martha noted in her presentation, if you ever get audited or investigated by a city or state agency that enforces these laws, they're going to ask, and they're going to see that the schedule said, okay, Martha was supposed to come in from 9 to 5, but Martha on July 11th, 2024, clocked in at 8:33. And if you don't have records showing that Martha clocked in at 8:33 but was just drinking coffee by the coffee machine and doing no work, and she didn't get authority to clock in, the agency is going to see that and say, well, that was a shift addition. Do you have consent for it? Did you provide Martha with a notice of right to decline that shift addition? Likewise, if you're in a situation where a manager needs to fill hours because other employees have called out sick, and you don't get the consents or provide rights to decline additional hours, you're going to get dinged. And as we'll talk towards the end of this session, the consequences for not providing the right type of consents or getting the right type of acknowledgments showing that employees left on their own volition have dire consequences. Like, just for example, what New York City is always top of mind, that could be between penalties you owe the employee and penalties you owe the city. For each instance where an employee left early that's unexplained, that could be up to $875 per instance. So these are penalties. Not having the right documentation in these instances could have really dire consequences, where the monetary remuneration that you'd owe upon investigation stacks up really, really quickly to really obscene amounts. So just talking generally, among most jurisdictions, what happens when there are employer-initiated schedule changes? And again, when we're talking about employer-initiated schedule changes, typically what we're talking about is a situation where I'm asking an employee who wasn't scheduled to cover for another employee's shift, or I'm asking them to work late on a certain day. But also, and this is where it gets really tricky again, is a situation where an employee is going to be working usually 10-15 minutes past their scheduled end time of that shift, because those are considered by most of these statutes, if not all of these statutes, an employer initiated schedule change. So in any of these situations where you're adding a shift that wasn't previously on the schedule with a lot of advance notice, or even a same day enlargement of the shift, or even a reduction of the shift, there are 4 typical steps that are required. The first one is obviously to tell the employee about it, and that telling the employee about it comes in various forms depending on the jurisdiction you're in. In New York City, in Chicago, and in Evanston, Illinois, prompt notice includes updating the prior version of the schedule to reflect the new shifts being provided to that employee whose schedule is changing. So that would require a posting of a new schedule. If you have an electronic and automated scheduling system, it would require publishing a new version of the schedule that was previously published and disseminated to employees. And the updated version should reflect the new schedule change and the new schedule being worked. And if that also includes a schedule being removed from an employee who called out sick or just can't make it for whatever reason, showing that employee A basically substituted for employee B. In other jurisdictions, such as Los Angeles, it requires written notice to that employee. The statute itself and the regs don't really clarify what type of written notice. It certainly can be in an updated schedule, but it also could probably be a text message or some sort of email or any such type of communication to the employee that we are changing your schedule for such and such date and for such and such shifts that were previously scheduled for such and such hours. Emeryville and San Francisco also require documented notice, and that's probably similar to the written notice. The regs and the FAQs don't give a whole lot of guidance about what they mean by written notice or documented notice, but again, we advise that either updating the schedule is certainly a best practice, but also providing some written communication. Written could be email, text message, or updating a scheduling platform that does identify the type of schedule change that is being presented to that employee. Again, as we noted, the second step typically required in most of the jurisdictions is reposting the schedule within 24 hours. So that the difference here is between step number one, which is notifying the affected employee of the schedule change. Reposting the schedule requires actual physical posting of the schedule either on the corkboard where schedules are typically published and posted, or updating an electronic platform that employees can access that show everybody's schedule. So step one is individual notification. Step two is notification to the staff writ large. The third important note that most jurisdictions Fair Workweek laws require when an employer is changing a schedule is providing an employee the right to decline working the additional hours or an actual affirmative requirement to obtain written consent before the schedule is changed. This is a very interesting and tricky distinction. The right to the statutes that have a right to decline typically are understood to mean an employer can make that change unilaterally, provided that they give the employee the right notification of their right to say, I don't want to work these additional hours, or I want to leave at my scheduled time. I don't want to work an extra hour beyond my schedule. You don't have to get their consent in these right to decline jurisdictions. You just have to provide the notice to the employee that they can decline working additional hours or additional shifts. The jurisdictions that have affirmative consent requirements, and New York City is in fact one of them, require typically an additional step. So if you want Andy to work a shift on Friday that he wasn't previously scheduled for, you cannot update the schedule until you've gotten Andy's affirmative written consent. And again, when we're using the term written, it could be electronic or it could be through text message, but it cannot be just Andy saying, yes, I will work that shift, because that is just words, and you will need, in the event of an audit, an actual physical, either electronic documentation supporting that Andy consented, or an actual written paper form showing that Andy consented to work that extra time. There are some jurisdictions like Chicago which seem to conflate the terms of right to decline and consent. Like in Chicago, the statute says before you add hours, you have to tell the employee of their right to decline. But otherwise, you can do it as long as you've given the right to decline, they haven't declined. But then in Chicago's rules and FAQs, they do seem to conflate that right to decline with the requirement to provide affirmative consent. So there's considerable ambiguity in places like Chicago about what to do if you want to add hours or you want to add shifts to an employee's schedule. So that can be a tricky issue, and we certainly suggest that if you operate in places like Chicago, you confer with counsel about how to best go about documenting that you've gotten an employee's acknowledgement at minimum, or consent before you update schedules and add hours. One other thing about the right to decline and consent requirement, typically this is not required when you're reducing hours. The right to consent or providing notice of the right to decline typically only deal with situations where you're adding shifts or that you're adding hours to an employee. Employers typically have the right to cut hours, and I would say that does not exist in New York City, but probably does. You can cut hours by simply paying premium pay, but you don't need an employee's consent to cut their hours. Again, I'm going to editorialize a bit here. This is a particularly difficult area of the law to comply with. And it is one in which, in my experience anyway, city enforcement agencies have come down really hard against my clients. And I think very unfairly, because like I said, this is typically a situation where you're adding shifts or adding hours. From investigations I've conducted, employers are typically glad to receive offers to work more time. After all, they're getting paid for that time. And I have yet to come across in 7 years of representing clients in Fair Workweek issues, a situation where an employer was even accused of, let alone actually did this, forced an employee to work against their will. I'm sure it has happened in the course of human history, but I have not seen it in a Fair Workweek investigation context. Yet, in my experience, particularly with the New York City agency that enforces the law, the bulk of penalties that the city assesses is in not getting or not having evidence of procuring written consent from employees to work additional hours in advance of those hours actually being worked. And the primary times where this happens is where, again, Andy was scheduled to work 9 to 5. Andy was dealing with a guest or a customer. And instead of leaving at 5 on the dot, Andy clocks out at 5:27. That's more than the 15-minute grace period that the New York City statute provides. And if you're ever investigated, the city will see the schedule. It says Andy's supposed to leave at 5. They will see the time records. Andy actually left out at 5:27. The city will ask for all consent forms. There will not be a consent form in this situation. And the city will assess the statutory penalties, which is $300 employee relief to Andy, $500 penalty to the city. And that's an $800 penalty just because Andy was a diligent worker and he didn't want to leave when he was seeing a customer and helping a customer. And it's unfair. And in my experience, like I said, representing clients in these types of investigations, this is where we see the bulk of the penalties. And it has turned the Fair Workweek law into a record-keeping law rather than a law that's truly designed to, protect employees' rights and work schedules where they don't want to work. And it just, to me, this is, like I said, I was editorializing, but this is where the law has really gone off the rails. But getting back on track, and sorry for that diversion for a little bit, typically the fourth instance of what happens, or a requirement or a result of an employer-initiated schedule change, is the requirement to pay premium pay. Premium pay differs in jurisdictions, and I believe Martha we'll get to actually, I'll be covering that. We'll talk about the premium pay within the jurisdictions. But if an employer is modifying an employee's schedule, typically they will owe premium pay to that employee as a result of the schedule change. In most jurisdictions, the premium pay is just is based, if it differs whether it is a reduction of hours or an addition of hours. It is typically tied to the employee's regular rate of pay. New York City, again, here is a bit of an outlier. They have a flat penalty value that is tied to the amount of time given for the schedule change. Generally speaking, though, the amount of premium pay owed is triggered and looked at by the time that you were required to post the employee's schedule. There's also a higher amount of premium pay owed if it is a last minute schedule change. So for example, in the example I was giving just a few minutes earlier, where Andy was scheduled to work between 9 to 5, but works from 5:27 instead. That is an example of a last minute schedule change with less than 24 hours notice. That will be an example of the most amount of premium pay owed for all types of schedule changes. And also, generally speaking, the amount of premium pay owed for shift reductions is significantly more than the amount of premium pay owed for shift additions. Next slide, and next slide details the amount of premium pay owed for different types of schedule changes in different jurisdictions. I don't want to go through this in tremendous detail, but like I noted earlier, if the schedule change results in no lost hours, or in no lost hours or added hours, typically the amount is just an hour premium pay at the regular rate of pay. If it's for lost hours, typically the amount of premium pay being owed would be based on the amounts cut from the schedule. There is some jurisdictions like Berkeley and Emeryville have a cap of premium pay owed, even if it's a large schedule shift cut. New York, again, is based on, and New York's premium pay is only owed for fast food employers, not retailers. So that is something to note. But that is simply based on a set schedule. Check your own local jurisdiction's rules, make sure you're doing this properly. There are differences among the jurisdictions, and you can certainly use the charts we've presented as a guide. And with that, I'll kick it off to Martha again.
All right, so let's talk about exceptions to predictability pay. So just to review, in general, if it's an employer-initiated change, then after the schedule posting deadline, in general, most jurisdictions require predictability pay. As you saw in the prior charts, the deadline by which predictability pay is triggered varies a bit by jurisdiction. Some penalize truly last minute changes more, but most of the jurisdictions are looking at changes after the schedule posting deadline. That being said, there is a host of exceptions to predictability pay, and they significantly differ by jurisdiction. So it is kind of tricky to, it is possible to program these things, but you have to take a jurisdiction by jurisdiction approach to make sure that what you're programming is actually correct. So just to run through at a high level what some of the types of predictability pay exceptions are in some of the jurisdictions. Well, of course, if the change was not employer initiated, if it instead was employee initiated, no predictability pay would be due. That's like an absence, vacation, sick, late. But as we've said, those have to be documented, and in most cases, documented by the employee, not by the supervisor saying Jane was late. It's much preferable to have an electronic record or a log or a form where Jane says I was late. That's why these laws are so difficult, because Jane doesn't want to say she was late in writing anywhere. And so employers are chasing around employees trying to get them to say they were late. So difficult stuff. Another exception to predictability pay is if the changes were in the shift start or end grace period. Those are those 15, 20 minute, a half hour in a couple jurisdictions. They give you leeway. They don't really consider those a schedule change or significant variance. So you don't have to pay predictability pay if it's within those grace periods. Some jurisdictions say, obviously if you terminate somebody, you don't have to pay them predictability pay for all the schedules that were posted that they're not working because they were fired or they quit. And then for suspensions, this has become a tricky issue in some jurisdictions. If you're not going to pay you have to pay predictability pay for the suspension in some jurisdictions unless it's a multi-day documented suspension. So if you just send somebody home because they did something bad for the day, you could end up having to pay predictability pay for cutting cutting their shift. So it could be if you sent them home for 4 hours, the last 4 hours of their shift, you could end up having to pay 2 hours of predictability pay, which is really grates on some employers. So you want to think strategically about how to discipline employees or just, pay the predictability pay. There's safety exceptions like a force majeure event, threats to safety, failure of public utilities, but they are very specifically defined, and you want to make sure that you just don't assume that the bad weather event or that the issue going on in the building would qualify as an exception. You need to specifically look it up to make sure it falls within it before you don't pay predictability pay when you tell people not to come to work or you send them home. In some jurisdictions, you can ask for volunteers to leave early. And if somebody volunteers, then they would, of course, this all has to be in writing, then you might not have to pay predictability pay in some jurisdictions like Philadelphia, but other jurisdictions that's considered an employer-initiated schedule change and you would have to pay it. So again, this is a limited exception that applies in Philadelphia. It doesn't apply other places. We're going to talk about posting hours before you external hire to fill them. Some jurisdictions say that you have to pay predictability pay if an existing employee accepts those hours within the currently posted schedules. Some jurisdictions say because it's totally voluntary, they don't have to apply to get those hours. You don't have to pay predictability pay, but as many employers are surprised that in some jurisdictions like Philadelphia, they specifically say predictability pay could be owed if the employee accepts those hours and it's within their posted schedule. So it would be adding hours to their posted schedule. Chicago is looser in this sense. Mutual agreement in writing to change the schedule, that's allowed and you don't have to pay predictability pay. Some jurisdictions say that if the extra hours are paid at an overtime rate, then that's an exception to predictability pay. But we've had a heck of a time trying to figure out how that really works operationally because does it mean that it's at the end of the work week and so it's the 42nd and 43rd hours, or if it's in addition to the total scheduled hours and beyond your schedule that would put you into overtime? We're not really quite sure how to compute it, and we don't really have any guidance. So some employers are just not relying on this exception at all because it's murky. There's some jurisdictions have a mass written communication exception. So for example, if someone can't work their schedule, the employer can do a mass written communication. So it could be electronic or posting something in writing or texting everybody who's impacted. Hey, Jane can't work her scheduled shift. Can somebody cover? And if somebody covers, then you don't have to pay them predictability pay. But in some jurisdictions, you cannot use this just for an extra shift that was never scheduled. It really is limited to not being able to work a coworker not being able to work a previously scheduled shift. So you need to look at the rules on mass communication before relying on that and not paying predictability pay. Oregon has a voluntary standby list, which would be an exception. And then employee self-scheduling, that's an important exception, but it only is, as far as I know, in Evanston and Chicago, where if the way you work your scheduling is employee self-schedule, then you don't have to pay predictability pay if they change their schedule. Then there are some industry-specific rules like for ticketed events, hotel banquets, manufacturing, production, or supply chain delays, and healthcare emergencies. So there are exceptions to predictability pay. They're just highly specific, and you're going to want to make sure that you review the guide, not only the law, but the regs and also the FAQs so that you have a good understanding of the extent to which they apply to your situation. Then I'll turn it back over to Andy.
Thank you. I'm going to start to sound like a broken record here in this section. Most schedule changes will in fact be employee initiated. The challenge, as we've discussed, is to document it and to separate it from employer initiated. So, one thing I want to point out, which was previously discussed, Chicago where the ordinance is different from the rules, which is different from the FAQs. An important issue here, which comes up often, is the mutually agreed to exception. So in the ordinance specifically, it says a work schedule change that is mutually agreed to by the covered employee and employer and is confirmed in writing, no predictability pay is owed. That seems pretty simple and straightforward on its face. The city of Chicago thinks otherwise, and this has become a source of litigation, and it's something we fought over for years. The example that they give in their clarification, and we're going to kind of get to this example later on, but it paints the picture well here, is if the employer has 3 covered employees call off from the second shift, the first shift is still working, and the manager walks around the business and asks out loud, can anyone stay late? You would think that by agreeing to this open offer to no one in particular, that it would be a mutual exception and that no predictability pay would be owed. But that would in fact be wrong according to the city of Chicago. They deem this an employer-initiated change and state specifically that for this mutual agreement exception to apply, the mutual agreement must be executed pursuant to an informed consent process whereby the employee knows that they have a right to decline and knows that they could be predictability pay. Meaning here that the employer, this manager in this instance, should, when an employee accepts, say you have a right to decline, and you acknowledge that, and basically, do you want to get predictability pay on top of the additional shift? And the employee could either take the free money or reject it, because they would have a right to, by the city's understanding, the employee needs to understand that they'd have a right to predictability pay. So that's one of these issues that we've talked about where the laws don't match up. It's not applied how you would think. So we've kind of talked about this. Written consent is needed, and depending on the jurisdiction, predictability pay may be owed. Here's another one that comes up often. If Ailey is scheduled for a shift on April 28th from 9 to 5, the manager cancels the shift but adds it on the next day from 9 to 5. You could consider this a shift change with no loss of hours, so 1 hour predictability pay. However, if the changes are made at separate times, meaning the 428 shift is canceled and then the next day 429 is added, 2 aspects of predictability, 2 premium payments would be owed, 1 for the cancellation and 1 for the addition. Openings, right to rest. So what these govern here is the length of time between 2 shifts. If you have a shift Wednesday to Thursday and another shift Thursday, depending on the jurisdiction, you need to have between 9 and 11 hours between the Wednesday shift and the Thursday shift. To schedule shifts with less time, you need written consent. Some jurisdictions like Philadelphia you can't permit ongoing consent. Others require consent for each and every shift that would violate this ordinance, this aspect. Now, one thing to keep in mind too is it's not just a matter of scheduling. For example, if on Monday you have a shift from 2 p.m. to 10 p.m. and on Tuesday you have a shift from 8 a.m. to 2 p.m. and you're in a 9-hour, you're in Philadelphia, you're good. You have more than 9 hours between the shifts. But what happens if they stay late Monday and or arrive early Tuesday and all of a sudden it's less than 9 hours? You're going to need to catch that and pay the clopening penalty, which again varies per jurisdiction. Some jurisdictions here, Berkeley, Emeryville, LA, Oregon, and Seattle, it's 1.5 times the regular rate, but only for the period of time within that rest period window. Other jurisdictions, it's for the entire shift. So that entire second day shift would be at the premium rate. And as you see in Philadelphia and New York, there's simple flat rate penalties that apply.
Okay, turning it to access to hours now. Since we're getting to time, we'll go through this pretty quickly. Access to hours, it refers to the basic policy that is present in most of these laws that prohibit hiring new employees before you offer shifts or hours you'd otherwise be hiring for to your existing employees. What is common in virtually all of these laws is that you need to have a policy and post and distribute that policy that explains the process for posting the open shifts that you'd otherwise be hiring for, and for considering how you would consider granting those hours or shifts to your existing hires before you hire externally. Um, um, the Generally speaking, when you post the notice of the open shifts, and the notice should instruct your existing employees in how to apply for the additional hours. You have to identify the hours for which you'll be hiring. Um, the the notice will typically look like a calendar. It will say we're hiring for an opening shift on Monday, Tuesday, a midday shift on Wednesday and Thursday, and a closing shift Friday and Saturday, for example. It will also typically identify the position you're hiring for. Is it for is it for a cook position? Is it for a cashier position? Is it for a stock worker position? Is it for a maintenance position? Typically, also, the notices will require you to identify the process by which the employee can seek to apply for those hours. And in the event that there are more than one existing employees who are looking to get those additional hours, the notice should include as well the process by which the employer will choose between the two or more employees who have put in a request to work those hours. As I noted at the very beginning of the presentation, this is a very cumbersome process. I am not aware of a vendor that has been able to automate the process. So typically my clients are complying with the access to hours requirements simply by posting a paper notice whenever they are planning to hire employees to fill additional shifts. And to the extent that there are employees who are filing responses to claim the open shifts that are being hired, they are applying the criteria that needs to be in the notice of the open shifts manually by hand. Just a few other points to call out. You can't when you are determining who to hire. If existing employees are in fact applying for or seeking to claim the open shifts, you obviously can't discriminate based on the people who've exhibited an intent to claim the open shifts. Again, like everything else, not failing to keep records of the notices or the people who or written notices of the claimants who are seeking to recover the open shifts, there are steep penalties for that. And moving on, just to hours. I did want to talk about also the New York City just cause for hiring law, which is part of the Fair Workweek law. Again, this is something that just applies to New York City fast food employers. As I mentioned again at the beginning, at-will employment basically doesn't exist for New York City fast food workers. Any employee who lasts more than 30 days of employment cannot be fired, and or discharged, actually the term that the statute uses, but discharged means more than simply being fired. A discharge by the terms of the statute means a reduction by 15% or more of the hours that are promised in the regular schedule. And if you think back to about an hour ago when Martha was talking about good faith estimates, the regular schedule has replaced the New York City good faith requirement. And really it appears it's a very similar form. It's basically a calendar that shows the dates and times that a fast food employee in New York City would work. And any deviation by more than 15% is considered a discharge. And any employee who's discharged without good cause or who's discharged without a showing of bona fide economic reasons can seek back pay to recover those hours. So really what New York City is looking for by implementing the statute is fixed schedules. And by fixed schedules, I mean they want employees, fast food employees in New York City working the same days, same hours every single week until they decide they can no longer work those hours. If you vary them, penalties are extreme. Like I said, you'd owe back pay and potentially reinstatement. The only way you can legally and lawfully reduce hours for employees is if they have violated the terms of a written progressive discipline policy that is applied consistently throughout all employees, all fast food employees of that employer, or if you could show that the company is experiencing economic hardship. This is something that the city is enforcing vigorously. There's a lot of nuance. It requires obviously the adoption of a progressive discipline policy, which not many employers have had necessarily, one that complies with the regulations. So if this is something that applies to you, I would suggest looking into it and talking with counsel.
All right, notices, postings, and record keeping. These laws require generally mandatory postings in the workplace where people can see them, sometimes in multiple languages, depending on the percentage of employees that you have whose primary language is not English. And sometimes upon request in some jurisdictions, you need to translate these things. There are mandatory notices in the offer, hire, onboarding phase, as we've discussed, good faith estimate, notice of rights, policy for hiring externally. If you can do advanced consents, you definitely want to do that to have that so that you don't have to rely on each time getting written consent, but that there are only a few jurisdictions that allow that. And you want to show that you gave them the first schedule through the date of the posted schedules. Record keeping obligations are generally for 3 years. Philadelphia is 2 years, but it's a best practice to keep them for longer than 2 years because you may not get notice right away of a complaint. You have to keep all records that show compliance. You definitely want to consider storing them in a way that it's easier to retrieve them if you do get an investigation or a complaint. You want to think about reconciling this documentation real time on a weekly or biweekly basis, and self-auditing as you go, because then you'll be sure to catch misses. So our big compliance strategy is just to keep looking at this, have a regular cadence of looking at these processes and documentation, daily, weekly reconciliations. If your predictability pay process is manual and not automated, you definitely have to do that anyway. So you should check to make sure that you've got all the documentation to justify any variances or schedule changes. Periodic self-audits and submitting your Fair Workweek records to a designated storage area is recommended. If you put some of this stuff only in personnel files, once you get to the time when you've got a complaint, you're going to have to open every single personnel file to find what you need, because typically a complaint will involve everybody in the store during a certain time period, not just one person. So we wanted to talk just a little bit about recent developments. We've seen, aggressive enforcement in New York City, Seattle, very aggressive enforcement. Philadelphia is investigating mostly on a complaint basis. They're not out there doing audits unless they get a complaint. That could change. We've seen class actions in Philadelphia, and in Texas, the ordinance was invalidated by a preemption law passed on the state basis, but then the law was stricken by the courts and it's now on appeal. So Ailey, I don't know if you have any current information on the ULIS ordinance, but I think it is in effect. We've tried to confirm it with the jurisdiction, but nobody calls us back.
No, based on my Google research, I believe the law is in effect in ULIS.
Yeah, I mean, not that many employers have locations there, but it's something that if you are boots on the ground, you might just want to walk into the office and ask because they're not returning the phone calls. In terms of remedies, there's a wide scheme of remedies. Some of them are self-executing, like predictability pay, but then others are not. It's only payable, required to be paid if you get a complaint or an audit. But the penalties and fines can be extremely onerous because they can accumulate because they're on a per employee, per work week, or per infraction basis. And it can be a real moneymaker for the city. On top of that, they're presumed damages, liquidated damage, and if you get into a lawsuit, interest and attorney's fees and costs. So these are costly claims to defend. Everybody is struggling with compliance, especially with documenting schedule changes. That's really the biggest problem. But as Ailey alluded to, the posting hours before you hire externally for large employers, that's been a big lift to try to find a way to comply, and the penalties are really severe with respect to not complying with those obligations. So Ailey, I don't know if you want to wrap up. We're right at time, minute over.
Yeah, I think you ended on the right note. As I mentioned earlier, this is turned into a paperwork keeping law, and it is so important to make sure that you have processes in place to maintain the right paperwork, and whether that is providing consent forms before schedule changes are made or notice of right to decline shifts, but also make sure you have copies of your schedules and updated schedules when you update your schedules, and make sure you have documentation showing, if an employee is unilaterally changing their schedules, make sure you have documentation showing that. That's really the best defense to any of the claims that Martha was referring to. Other than that, we are here. If you have any questions, I see we have over 100 questions in the chat box. We will try to answer those after the call as quickly as possible, but we thank you for your time, for tuning in today, and please be in touch if you have questions. Thank you.
Martha, Ailey, and Andy, thank you so much for providing us with an in-depth look at Fair Workweek laws and providing insights on how our attendees today can remain compliant across the jurisdictions from coast to coast. For those of you in attendance, thank you for taking the time out of your day to join us on today's event. If you're interested in learning more, a survey has popped up on your screen. You may have to exit full screen mode to see it. Again, we're offering a complimentary demonstration for the Navigator Suite, which includes our predictive scheduling report, and it breaks down today's topic into subcategories, comparing policies across multiple jurisdictions to ensure your organization has all necessary policies implemented. Martha, Ailey, Andy, again, thank you so much. And everyone, we hope that you have a great rest of your afternoon.